the examination report. So before going to the file of the patent, is there anything so that we can understand that whether my idea is novel or not?
Yes. That's I just said that. Like from your end, you can perform the patentability search. Okay, from that patentability search, basically, you will search. You have to search like worldwide patent databases or non-patent literature.
Is it open access?
Yes, open access. Like there are few free databases, and also there are some paid databases. But the like the total documents that are available, that is same. Okay, the free databases, as you have to do, like there is some limitations. But if you search properly in that free databases also, believe me, you will get the document. It's
the
not.
The institute provides paid database also.
Okay.
So in the innovation tab on the institute website, if you go, there's some option for patent search. If you click that, it will directly take you over there.
Okay.
So what is the tool name?
Excel Scout.
Okay. So in that
Excel Scout.
Scout.
XL Scout.
Excel Scout. Yeah. So and again, like there are different paid databases, and like the searching criteria in different databases are different. Okay, so you have to understand like how the searching works in that paid database. Okay, so once you search and you find that your invention is fine to proceed, you can file the patent before the patent office. Okay, that is for patentability search. Okay, now this is the Indian specific drafting details. Okay. So in section 10.4, okay. So section we discussed about section 3 and 4, right? So now section 10.4. So this is regarding the enablement required. Okay. So what does it mean by enablement required? That means you are enabling other persons to implement your invention. Okay, that means like you have to very clearly write the patent specification such that the other person, you are enabling the other person to read your patent specification, they can implement their invention. So the enablement requirement is must. If you do not clearly write your patent specification, you will be objected under section 10.4 that your patent specification is not enabling the person skilled in the art to implement the invention. So the enablement requirement is a must requirement. So that is given in section 10.4. Now the second is clear and concise. Okay, so it should not be verbose. Suppose when you are writing the patent specification, you are writing and writing. So the main things you have mentioned somewhere, but that should not be the verbose. That should be clear and concise. Whatever things you want to claim or patent, just write that things only. Okay. So in a concise manner, prepare the patent specification such that it can comply with the requirement of the Indian Patents Act. Now there is a third is the unity of invention. Okay, unity of invention means suppose you have invented 3-4 inventions. Now you file all the 3-4 inventions in a single document. Now what is the advantage? Obviously you are saving the money of official fees, right? So to stop that one, there is a requirement of unity of invention. That means a single patent application will have only one concept, one inventive concept. Okay, so a single patent document must not include a more than one inventive concept. So you must comply with the requirement of unity of invention. Now there is another thing that is called the provisional or complete specification. Okay, so what is provisional and what is complete specification? So there is another thing when suppose you are doing the research from last 3 to 4 years, suppose. Okay. Now you have not filed any patent, so there is no proof from where you are doing the research, right? In patenting system, it is considered when you file the patent from that date onwards, you are doing the research. Okay. Now So for that reason, basically patent office provides two options. One is the provisional patent application, another is the provisional complete application. Basically for provisional patent application, whatever your specification is writing, that we call provisional patent specification. And for the complete patent application, whatever specification, whatever patent document you have to submit, that we call complete specification, complete patent specification. Okay. Now, the patent office provides you an option to file the provisional specification. Why? Suppose you have an idea. Okay. Now you want to protect that one. Because obviously once you have idea, you have suppose proof of concept you have prepared, and you found that that invention can be workable and it has a major impact in the day-to-day life. But it will take time to implement, right? So once you have the proof of concept, just go and file the provisional patent specification. Provisional patent application. That means you are saving the date. Okay, because the patent office will consider that you are performing you are doing the invention from the date of patent application. So whenever you have idea, you have made some proof of concept, go and file the provisional patent specification. In provisional patent specification, it is not required to provide full technical details. It is only the general overview, like how your invention is going to work. Okay, so once the idea is there, you have made some proof of concept, go and file the provisional patent application to save the date, because from that the patent filing date is very much important. Okay, now you have filed. Now there is a timeline within which you have to file the complete specification. So what is the timeline? That is the 1 year from the date of filing of the provisional patent application. So the Indian Patent Office is providing, it is same in US also, in EP also. So they are providing you the timeline of 1 year within which you have to implement whatever concept you have filed in the provisional patent specification. Now once you have implemented the whole thing, the complete specification, then you file the complete specification with the claims. Okay, so what is claims, how to write claims, we shall discuss. Okay, but just understand at first, so this date is very much important, because whenever the patent office is going to search your patent application, they will consider that date only. So prior to that date, is there any similar invention or not? If after that there is similar invention, they will not consider. So prior to that date, if there is no invention, your patent will be granted. So the date is very much important. Okay. So if you have any idea, you made the proof of concept out of it, and you found that your invention is going to work, just go and file the provisional patent application. And you have 1 year of timeline. Again, that can be extended up to 6 months, means total 18 months. But it is suggested not to take the extension, because then you are losing the prior date, the fast filing date, the fast provisional specification date. Sometimes it may happen, right? Like you will not be able to implement within 12 months. So that's why the patent office has provided the timeline of additional 6 months. So total 18 months you can take, but it is suggested not to take the extension, because once you are taking the extension, you are losing the priority date. The fast filing date we call as a priority date. Okay, so you are losing that priority date, because suppose you have filed 1st January 2025. Okay, now another invention came and they filed in the suppose 15th January. Suppose, okay, that invention will not be considered, because you have filed earlier to that invention. Now you have post-dated. Suppose you have post-dated 1 month. So your invention date will start from 1st February 2025. Then that whoever filed on 15th January, that patent document will be considered as a prior document of your invention. Okay. For that reason, it is suggested not to take the extension, but obviously there are some times that it is not possible to complete the whole invention. Then you can take extension, but as a whole, try to file the provisional patent application within 12 months, file the complete specification, then do the rest of the things. Okay. Okay. Then, so this is the thing, like the avoid exclusion under section 3. So, as I have already said, so when you are drafting the patent specification, please make sure that whatever wordings that is written, So suppose like I have just given like section 3I. So process of operation. So if you write the claim with that way, a process of operating that, it will immediately reject it. Okay, there will be no further examination. So they will raise the objection and they will reject it. They will not grant it. Okay, so that's why section 3 is very much important, and section 4 is also. Section 4 is related to the atomic energy. So if you are doing any invention out of atomic energy, you are not allowed to file the patent application. Okay, so always keep in mind the wordings or whatever that has been provided in section 3 and section 4. So try to avoid all those wordings while you are writing the patent specification. Okay, so now this is the content of the specifications. Okay, so we understood, right? Like what is the patent, what we call as patent drafting, what is the patent specification, right? Now we are going to discuss regarding the content of patent specification. Okay, so what are the contents that should be there within your patent specification? Obviously, there are certain rules and regulations that has been provided. So you have to comply with the legal requirement. So these are all the part of legal requirement. Obviously, you have to write the technical details clearly, but these are the part of legal requirement you have to comply with, because this patent specification we call as a techno-legal document. What we call? Techno-legal document. Okay, why? Because these patent specification includes the technical matter while complying the legal requirement. So that's why we call it as a techno-legal document. And if we like think of like how much percentage of knowledge we should have to write the patent specification, we can consider as 70 to 80% of technical knowledge and 20 to 30% as the legal knowledge, because the majorly technical matters need to be presented in the patent specification. And if you have 20 to 30% of legal knowledge, then you can write the patent specification. Okay, so another important thing, like as this patent specification includes the technical matter, the normal lawyer like who doesn't have the scientific or technical or engineering background, they cannot practice in this area. This is the only part of legal area which has to be practiced by either science graduate or engineering graduate or technological graduate. Okay, because this patent specification requires the technical knowledge as well as the legal knowledge. So you require both techno-legal knowledge to draft the patent specification. Okay. So at first, see in the specification the title and description of the invention. So like obviously, like when you are writing anything, like you all heard of like that journal and conference paper, right? So you have gone through, maybe you have gone through that one. So this title and description of the invention. So title is the like in a short, like there is a legal requirement. Like when you are writing the title, it should be within the 15 words. It should be within the 15 words. Okay. So if you write the title which is above the 15 words, then again you will get the objection. So you have to modify that one. So when you are writing the title, so that should be clearly disclose your invention, and that should be within 15 words only. And description is like the whole specification we are calling as a description. Now it must sufficiently and clearly describe the invention. Okay. So sufficiency of disclosure. Okay. So as I have already discussed, like the enablement of a person's skill in the art. So this is also called the sufficiency. Okay. Sufficiency means you have sufficiently described the whole invention. Okay. So whatever you have described, that is sufficient for the person's skill in the art to understand what technological things you want to patent and what are the problems you are solving to get that invention. And it should fairly describe the invention. Okay, so each and everything should be fairly described. So there should not be like the flow of writing should be in such a way that whenever anybody is reading your specification, they can really understand like what you want to claim or what you want to mention in your patent specification. Because as I have said, that patent specification is the primary document. That is the primary document which is required for the commercialization as well as for the technology transfer. Okay, and it is the basis of objection, opposition, whatever it may be. So the patent specification is a very important document. So that preparation of that is very much to be carefully made. Now the thing is that the section 10.5 it says that the base method for performing the invention must be disclosed. Okay. So suppose suppose you have filed the provisional patent specification. Now within 1 year, suppose you have tried different methods to reach out to your invention. Okay. Now there's obviously that should be on like best method, right? And there will be some method which are not like giving the result as of the best method, but obviously it is giving the result. In the patent specification, it is mandatory you have to give the best method and you have to describe it clearly. And like it is suggested to claim the best method, because obviously like whatever best thing you are getting, you want to patent on that part, right? So it is suggested whatever the best method you have invented out of your invention, you have to mention that one in the patent specification. And yes, so the best method, so that should be there, right? And the section 10.6, it is written like claims define the scope of the protection. Now, what does it mean by scope? What does it mean by scope? Okay. Suppose like I am giving just example. Okay. So suppose like you buy one land. Okay. So you are giving the fence out of that. So you have right within that fence only. So your scope is limited within that fence, right? You can give the wall, you can give the fence, whatever you want, because that land belongs to you, correct? So that we can see, we can feel, but this is the intellectual property. Patent is the intellectual property, right? We cannot see, we cannot feel. Here also we have to define a fence such that the scope is defined clearly, and when you are claiming, you will be protected within that fence only. If anybody wants to come inside your patented product, you can enforce it. Please do not use, this is my property. So you have to clearly define that fence. How you will define? You have to write the claim in such a way that you can define that fence. Okay. Now how you can increase the fence, how you can decrease the fence, that is different. So suppose you are saying ki the whole India belongs to me. So is that possible? That is not possible, right? So if you write a claim in such a way, this is very broad, you will not get patent out of it. Now if you say only this place belongs to me, I do not want to move here, so that is also not possible, right? So the patent claim should not be written in such a way you define a very narrow scope. So it should be in between these two things, okay? Such that like whatever invention you have made, that should be clearly disclosed, and whatever fence you are defining, that should be clearly disclosed based on the wording of your claim only. Right, so the wording is very important, like how you are claiming the whole thing, how you are writing the specification. So based on that one, basically you can define your scope of your invention, and that should be like clearly defined. Okay, so that's why the claims define the scope of protection. Okay, another thing. So as I have just provided, like there are two types of specification. One is the provisional, another is the complete. Okay. In provisional specification, as you have not implemented the whole concept, so the claims are not required in the provisional specification. Okay, because in the provisional specification, you are just defining the concept. Okay, you are just telling I have this idea, I make some proof of concept, so I can make this invention like by implementing it. Okay, for that reason, the provisional patent specification doesn't require any claim to be defined. Okay, but whenever you are filing the complete specification, the claims must be there, and these scope, like the frames, whatever I am just describing to you, that must be defined by the proper wording of your claim subject matter. Understood? Okay. Now, so we understood the claims concept. Okay, so these claims is the heart and soul of the patent specification. So how to write, like obviously like that you can like master based on the practice, but at least you can understand how to write. What are the different parts of claims? Like how you proceed with the drafting. Okay. And the last thing is the abstract is the mandatory for technical disclosure. So we all understand regarding the abstract. So this is the short technical description what you have to give for your invention, such that, see, as he is asking, like suppose we want to perform a patentability search. Okay, so while you are performing patentability search, there will thousands of documents that will come into a role. So it is not possible to read each and every patent specification, right? So the patent specification may contain 30 pages, 50 pages, 60 pages. So it is not possible at all. So what we do, we generally read the abstract. We generally see the drawings. We see the claims. Okay. By seeing these things, we can understand like whether the patent, whatever they have filed, that is related to our invention or not. Right? By understanding that, or if we found, suppose out of 100 documents, we found these 4 or 10 documents. Suppose we found these 10 documents are related to our invention. So we select only those 10 documents. And we will read the whole specification of that to understand whether our invention has any inventiveness over those 10 documents only. Okay. So to select 10 documents out of 100, so you have to only read the abstract, drawings, and claims. Okay. So that's why this abstract is a mandatory part. And again, there is a legal requirement. Okay. As I just said, so for title, how many maximum words? 15, right? Right. Now for abstract, there is again a legal requirement, that is 150. So whenever you are writing the abstract, you have to mention the technical details clearly, but the maximum words that you can write within the abstract, that is 150 words. Okay. Understood?
Sir,
Yes,
sir, I
please.
had a question regarding atomic energy. You said more like in section 4 related to atomic energy. So I was asking that if it has certain utility, if certain rays can be used for sterilization of products like food or beverages or something, so can it be patented like if there is some other rays like X-ray was invented?
No, see, X-ray is not atomic energy related, right? So, because these atomic related things are not allowed to get patent because these may have other implications also, correct? For that reason, like generally these atomic related research, whatever that is going on, that generally are within the like government offices only, right? Outside of government office, like it is very rare to use that atomic because that has many different implications. For that reason, basically that section force parts to have the patent file on the atomic energy related things. Okay, so this is only for that reason only. So will not get patent. Like even if you file, that will going to reject. Okay.
We can take a break and ask.
Yes, I think we can take
questions
on
again.
break. So I hope like at least basic concept you understood, right? Okay. So I think we can take break and you can continue.
Yeah. If there's any question you can ask, or otherwise we can take a break.
Sir, in the initial slides,
Yes.
you mentioned that mental act comes under PM.
Okay. 1 minute. Yes, this one, right?
And if mental acts come, then what will be the difference between mental act and IPR?
No. See, IPR means obviously like mental act means when you are playing chess, that is the mental act, right? So you are moving each and every day with respect of your mental calculation. So that mental calculation you cannot patent it. But suppose as an example, you have invented the pen. Okay, so previously what was happening, like you cannot write with pencil. Okay, so you have invented and you have implemented that one. So you can get the physical embodiment of that one. Okay, so when you are playing the chess, there is no such physical embodiment. out of it. So you are playing with respect of your mental implications. So you are thinking and you are moving, but there is no physical implementation, physical embodiment of that product, of this thing. Okay. So when you have the physical embodiment, you can file the patent, but the mental scheme you cannot file.
Mathematical algorithm, if somebody invent some new algorithm,
Yes.
yeah. If somebody want to invent the new algorithm, then why not?
If you just claim the algorithm, we will not get the patent. But to overcome that objection, if you claim its process step, okay, and if you write the claim that these processes are being implemented or executed with respect to some hardware, then we are avoiding the algorithm. Algorithm is certain steps, okay, but there is no hardware implementation. So if you write the process step in accordance with the hardware implementation, and you can showcase that these process steps along with the hardware things are giving some advantages, then you will get the patent. But only writing the algorithm you will not. Okay, so the section 3 we can obviate, like previously the Indian patent was very much restrictive regarding this 3K, but as of now, like everything, whatever we are using, that is based on the computer program, right? Like, even you are using like washing machine or whatever, so everywhere the computer programs are required, right? So, but we want to showcase in such a way that we are not just claiming the computer program parts or algorithms. We just write with respect to these hardware things, this program or like algorithm is giving such a result. Then you will eligible to get the patent. Yes.
What will happen when we exceed this word limit? Example, if I'm writing an abstract and it's exceeding 150 words, what will happen?
You have to reduce it.
Reduce it, or it will just cut down 150 and then left it down?
No, yeah. You have to reduce it. See, if you file that on, like they will raise the objection and you have to rewrite the abstract such that like these are the formal requirements. Okay, so but like there is a requirement on title and abstract. Other things you write whatever you want, but that should not be in verbose in nature, right? That should be clear and concise. Yes.
Can I ask?
Yes, please.
How can we decide the scope of claims in a patent?
We shall discuss. There is like 2-3 slides on which I'll showcase, okay, like different wordings, how different wordings can define the scope of your invention. By such way, you have to write it by choosing the appropriate word so that you can define that particular scope. So that is there. So we'll discuss it in that way. Yes.
Can I say?
Yes.
So in your quiz slide, there was one term is that the new chemical compound with therapeutic effect that can be patented.
Right.
So suppose we have similar kind of new chemical compound that have some clinical application.
Okay.
Suppose they are sensing some biomacromolecules which has some tremendous clinical applications. Okay. Now we have synthesized it. We have some we did some research with this. We have some preliminary result. Now we want to simultaneously do patent as well as we want to publish the result as a scientific journal. So which I should do first and which I should do last? And if I file a patent, shall I get immediately a patent number, and with this patent number shall I proceed with the publication?
Very good question. So like as a innovator or student, you should know, because in our universities that the journal publication as well as patent application has a different type of implications, right? So for your question, it is always suggested to file the patent application at first. Okay, why? Because for a journal there is no such requirement. Is there any requirement like in journal? See, as you are the same inventor for your patent as well as journal, so it is suggested to file the patent at first. And once you file the patent, so suppose you go for the provisional patent application. Once you file, you get the application number. Okay, immediately you get the application number. Okay, so once you get the application number, then you go and file the publication details, because it is always suggested prior to the date of your patent, there should not be any publication. It is always suggested. See, there are few exceptions. Suppose like there are 3 inventors. Okay, they are filing the journal as well as the patent. So there is an exception of 1 year timeline. Suppose you do not know, you have filed the journal that get published. Okay, so there is one exception. Within 1 year from the date of publication, you can file the patent, but you have to give the declaration. Okay, that but the main thing is the number of inventors in the journal publication as well as the patent specification should be the same. Otherwise, like you will get another objection also. Suppose you have filed the journal publication and it gets published, and then you file the patent application. Now the patent office found that there is a publication of your similar invention that get published before the patent application. So you can give the declaration. So this is my invention only that got published. I was not aware, but it is always suggested to get the patent application number at first, then go for the journal publication. Okay. Yes.
1 year is the limitation.
Yes.
Time.
Yes.
So let's say if it is 3 years. it's not
No.
possible.
That will be considered as a prior document.
Let's say journal we have published 3 institute we are together. So then and I am filing from this institute because I am affiliated in this institute. So we have to mention that other institute also.
No, see, if that is already crossed 1 year, that is if that is already crossed 1 year,
It's close 1 year.
then like you will not get the patent because
Okay. Let's say it is within 1 year, and I am published this thing with some other collaborator, which is not belongs to our same institute.
yeah, then like obviously there will be objection. You have to give the like their declaration. Okay.
Okay.
That
But they don't have any objection
Ha.
to file like
you can file that one, but like remember it within 1 year it is allowed. After 1 year, if that patent document is published, it will be considered as a prior, not your invention.
Okay. But it can be.
Like see, that it is suggested if already 3 years gone,
Okay.
include something new out of it, because 3 years is a like very much of time, right? So you include something new which will give some inventiveness over already published document. Then you can file the patent. This is the new thing that is inventive with respect to whatever I have filed in the journal application. In that way, you can obviate those objections.
And the author sequence will be the same?
No. Okay, this is another question I should clarify. In journal, actually, there is a concept of first author, second author, third author, correct? And you get like some points or something according the sequence of the author name, correct? But in patent, it is nowhere the case. Each and every author, like inventor, okay, what is applicant and what is inventor? At first, we have to know that one. Suppose you are performing a research within this institute, okay, so you are using institute like whatever they are providing, okay, machines, these ACs, buildings, all those things. So the applicant, like NAM make or I don't know, so whatever patent that has been filed, it is okay. So can we take these questions after this break? Okay, we can take these questions. Okay. So what is applicant, what is inventor, and sequence of inventor? I will start in the next session. Okay. Then we will take on. And so I was discussing regarding like what is applicant and what is inventor, right? So applicant is the owner of the patent application. Okay. So as I was saying that suppose you are working under IIT, ISL, Bangalore, and they are providing all the necessary hardware features, rooms, hardware like machines and all those things, rooms and other infrastructures. As they are providing you, so whatever you are doing or inventing within this university, when you are filing the patent application, the applicant would be the IIT ISM Dhanbad. That means the owner of the patent application would be IIT ISM Dhanbad, and you would be the inventor. Okay, because you have invented the things, but the applicant is the owner. So suppose when you are out of this institute and you are doing something by your own, so you can file patent application by claiming applicant as well as inventor by your own. At that moment, you will be the inventor who has invented the new things, as well as you will be the applicant. That means you will be the owner of the patent application. Okay. Now we were discussing regarding that there are exclusive rights that has been assigned when you are filing the patent, right? So these exclusive right that will be assigned to whom? To the applicant or the inventor? To whom? What do you think? Applicant, correct. Because applicant is the owner of that patent application. Okay, so you have invented that thing, and there is one formal requirement that has to be complied with. When you are inventing and you are giving your disclosure to the institute, and when that patent has been filed, you have to provide the proof of right. What does it mean? That means as you have invented, so the primary owner would be you, and then you are transferring your right to institute. Then that institute will be considered as the owner of the IP rights. Okay, so there are certain, like we found one situation, like we filed one patent application in NIT Durgapur. So in that cases, basically they were collaborating with one doctor who is outside from NIT Durgapur. Okay, and they did not have their internal like anything between them. Okay. And after that, they filed the patent in the name of NIT Durgapur, and that doctor, he has refused to sign that proof of right document. So as he has refused, that means the rights which that doctor owns, he did not transfer that to the applicant, to the NIT Durgapur. That patent got refused only on the reason that that doctor has not signed that proof of right document. Okay. So when you are inventing something, the primary owner would be you, but as you are using the infrastructure of this institute, the institute would be the owner of this patent application. But for that reason, what you have to do, you have to give the proof of right. That means you have to assign your right to the institute such that further commercialization or whatever it may be, that can be executed by the institute without requiring your further approval. Correct? So I hope you have understood the concept of applicant as well as the inventor. Right? Another thing, okay. Applicant may be the natural person or the institute or the company. Applicant may be the natural person or the institute or the company. But the inventor must be the natural person. Because this is the intellectual property, and intellectual property cannot be generated by any company or institute without help of human intervention. Okay, for that reason, inventor must be the natural person, but the applicant may be the natural person or the institute or the company or the startup is a company, or the partnership firm, whatever it may be. Okay, but the inventor must be is a natural person. Okay, so there are certain case laws that is a very hot topic that is going on. Like AI has invented something. Okay, that has been filed in US and also Australia. Now, as AI is not a natural person, and also like AI has certain like intelligence, right? They have filed a patent. They have like claiming as AI has done this one, AI should be the inventor. But in US that got rejected. But I think in some country that has been accepted. But in India, as of now, the inventor should be the natural person, right? Okay, so this is the sample patent specification structure. So it should be the patent specification structure. So in the patent specification, like we have already discussed, right? So the first one is the title of the invention. So you have to suitably define the title. So within 15 words, that title should provide the information what your invention is related about. Okay. Then you have to provide. I will show you one specification. Okay, just understand that one. Then I will show you one graph that has already been filed and that has been granted. So I'll show you that one. So after the title of the invention, there would be the field of invention. Okay, so field may be in different sector. It may be from the agriculture sector, it may be from the pharmaceutical sector, it may be from the computer science domain, it may be from the electronics or electrical, whatever it may be. So the field of invention will include from which field of technology you are filing this patent application. After that, the background and the prior art. So what this section includes? Background and prior art relates to, so what are the related disclosure or published document that are already available that is related to your patent specification. Okay, in that background, like you have to mention, so these are prior arts are already available in the market, and I have done this invention out of these different prior art document. Okay, so it may not be possible that you will find all the prior art document, but try to provide at least few documents so that you can disclose that these prior arts are present from my field of invention, and I have considered these to find out the problem of these documents. So in the background section, what we will write? We will write different document, prior art document. It may be the patent literature, it may be the non-patent literature, and then we will discuss what are the problems that are available in those documents, and we are solving that problem through our new invention. So for that reason, we are filing this patent specification. So in this background section is very important because this background section you have to clearly write what are the problem. Okay, because if you do not showcase the problem solution statement in a clear way, the examiner would not be able to understand and they will raise the objection. Okay, so this background section is very important. Like you have to clearly mention what are the prior art and what are the technology that are available related to your invention, and what the problem you are facing as of now with respect to those prior art documents to this. So no solutions would be there in the background section. Background section only what are the documents and what are the problems. Okay, one last paragraph will be there. To solve this problem, our invention has arrived. Nothing more than that. Then summary of the invention. Summary of the invention means the whole invention in a summarized format. Okay, there is a legal requirement for abstract, but there is no legal requirement for the summary. So you can write in a short format. Obviously, see, as I have just discussed, right? So for the patentability chart. So there may be hundred of documents. So someone will read at first abstract, then the drawing, summary, claims. So these summaries would be in a summarized format. So whatever invention you have made, that you have to write in a summarized format, so that if any person after abstract want to go further of your invention, they should start with summary. Okay. Then the brief description of the drawing. So the drawing means whatever you have filed, so you have to provide with appropriate drawings. So if suppose as I have said, it may be a product or maybe a process. Okay, so when you are filing the product, you have that drawing. So whatever product. So whenever you are filing a process, you have to provide this flow step. Okay, steps of method. So by that way, my process is executing. And that is very shortly, obviously, and you have to provide all the details in the next section. That is the detailed description. Okay, in that detailed description, what you have to do, you have to define each and every component that you have write in the claims as well as you have given in the drawing. Okay, and what are the interrelation between all those components and how they are working together to solve the problem you have written in the background section. So in the background section, we have written the problem, right? In the detailed section, we are writing how these components or whatever we have claimed, how these are working together to solve the problem that we write in the background section. Then the most important part of the patent specification, that is the claims. Okay, so as I have discussed, you have to define a phase, the scope of your patent specification, that will be defined by the claims only. Okay, so as I have said, you will be assigned with certain rights. Okay, certain exclusive rights. So that exclusive right only be dependent on the claims. Whatever claim you are writing, the exclusive right will be granted out of that claims only. Okay, so that is the heart and soul of your patent application. So for that reason, like I have included one slide. So how to like effectively draft the patent specification. So for that reason, when we get the disclosure, so at first we have tried to understand the problem solution statement. See, whenever you are inventor, you are drafting your own specification. You know, right, what is the problem and what is the solution we have made. But when we are working with many inventions. So at first we have to discuss with the inventor to understand what are the problem of the existing methods or products and what are the solution you are providing. So understanding the problem solution statement is a very crucial stage. And based on that one, so whatever solution you are providing, we have to draft that claims to define the scope. Once that is freezed, you can go with the drawing, you can prepare the drawing, then the all other like the fields, whatever I have mentioned, you can write all those things. Okay, so the defining or writing the claim is the most important part. Then abstract I have already discussed. So there is a legal requirement. So only 150 words maximum that is allowed to write the abstract. So it will only include the core technological part of your invention, and that should be within the 150 words. So if it is increased, you have to delete the thing. So that is simple. Okay, you have to meet the legal requirement. Okay, and then the drawings. Okay, in that drawings you have to clearly showcase how your invention is working. Okay, so I'm just giving you an example like how this works. So this is a very old one specification. Thomas Edison in the year of 1880. Can you imagine? Like 150 years ago, he has filed this patent application. See, this is the drawing. So this is related to the electric lamp. Okay. So this is the drawing by which you can clearly understand how it is working. See, at that time, basically there was no such type of like clear mentioning of how you write the specification and all those things. But this is just for your understanding. Like prior to 150 years, can you imagine? Like that time, there is a patent specification, and we can see that one. So it was filed in January 27, 1880, before the USPTO. Okay. United States Patent and Trademark Office. So you can see these things. So these are very easy, obviously, but at least they have that document. Okay. And see, there is a claim. See, I claim as my invention. Okay. So by defining the claim, he is basically like defining the scope of his invention. Okay. So an electric lamp for giving light by incidence consisting of a filament of carbon of high. In any case, like it is not that much of readable. So I just wanted to show like how these things were there before 150 years. Okay, so this is called the patent specification. So see, this is the physical embodiment. Okay, this drawing is a physical embodiment. How it is working? By seeing this, you cannot understand until and unless you draft the patent specification. And in this patent specification, you have to clearly write how these lights are coming. What are the technical effect by which you are getting that light. Okay, so that things are mentioned here. So this is the working functionality of the electric lamp. So this is called the patent specification. So this is very old. So I just kept it for your understanding. And this is very interesting. So see, it was filed in 1984. Okay, so around 50 years ago. So this is related to the banana peeling machine. Okay, so you understand like there is a like challenge where you peel the outer skin of the banana, right?
Is there any challenge?
No, suppose there is a requirement of giving like banana to thousands of people, so like it would be difficult. So this machine has been invented to overcome that problem. Once you keep that banana, it will like peel that, and it will like the outer skin will be rejected. So this see there are various drawings that has been given, okay, to clearly disclose how these inventions are working. See, there are I think 10 claims and 6 drawings. Okay, So see how these things are working. So these are the like different figures that has been provided, and see here this vanilla is getting paid. See in this document it is given. So like once we read that one, we can understand how the working functionality of this patent. So like by seeing, so like what I want to say, but seeing this only device, you cannot understand, right? Unless and until you are writing in the patent specification that what are the components that are present, how they are working together to ultimately build the value. So that things you have to write clearly in the patent specification. See, so these are the things, and these are the specification description. And this is the USPTO like a document, and obviously there will be a claim things. Here there must be here 1, 2. See, I claim. Okay, so this is the claim. So claim should be there because the claim is the thing on which you will get the protection. Okay, and with respect to Indian specification, I am showing this one. So this is the method and system for like enhancing handwriting content on a smart board. Okay, so see this is a field of invention. Then there is a background of invention. So I'll like show you how this patent specification you can get from the Indian Patent Office. So I'll also show this one. Okay, so see this is the field of invention. Then background of the invention. And then the background of the invention. See here actually I have mentioned the prior act, like what are the documents, what are the problem. Okay, see to overcome such problem, here it is written. Okay, so that means here I have written the problem. Okay, then this is the summary of the document. Here basically in a summarized form we have write how these inventions are working, and then this is the brief description of the drawing. Okay, so there is obviously there is a drawing part is there. So this is the drawing. So you can see like this the students or the learners, they are sitting in front of a smart board, and here someone is writing, and whatever he is writing it will be disclosed in this 104. Okay, now another thing, like see 100, 102, 106, 104, there are certain numbers, correct? So what we call this? We call this as a reference numerals. Okay, what we call a reference numerals. See, these are the numerals 104, 102, 101. So these are the numerals which is referring to a particular component. That's why we called it as a reference numerals. Okay, so what is the requirement of this? This see in the patent specification. See at first see this is the brief description of the drawing. Okay, so here what we have written. Figure 1 illustrates a schematic block diagram of a system for enhancing handwritten content on a smart board. Okay, in accordance with an embodiment of the, these are the called boilerplate. So these are basically this in accordance with an embodiment of the claim disclosure. So these are to comply with the legal requirement. Okay, and then basically this detailed description comes into the picture. Here again, we have to define some boilerplate. So these are basically the to comply with the legal requirement. And then see here, from here we have clearly disclosed the figure, how this figure 1 is working. See, as shown in figure 1, the system is configured for enhancing the smartboard 100. Okay, what is 100? You have to go to the drawing. So this is the 100. So from here you are referring that what reference numerals should be there checked in the drawing. So that's why this is the things you have to understand. Okay, so it is same like in every specification the reference numerals should be there, and again there are some legal requirements of the reference numerals. Okay, there are something like you cannot write things on the reference numerals part unless and until this is a method step. Okay, so you can see this is a method step we have defined. So set of step 1 the start, and then how it is working as a flow diagram we have given. Okay, so this is the detailed description whatever we have written. So say here see all the details we have mentioned, how it is working, and how see here we have also defined some mathematical expression. Okay, so as I have said, this mathematical expression we cannot write in the claims, but we can include that in the description to define how our invention is working. Okay, so inclusion of mathematical expression in the description is not a problem, but inclusion of that mathematical expression in the claims is a problem due to section 3K of our Patent Act. Okay, so that's why when you are writing the claim, you have to consider you should not include any mathematical expression in the claim subject matter. Okay, so these are the different mathematical expression by which we are clearly disclosing how these invention are working, and we have also given some examples to understand how the above mathematical expressions are working to give some output based on certain examples. And there are various mathematical expression and all those things, and after that, so there are some, these are not the mandatory legal requirement, okay, but generally it is suggested to provide advantages so that when the examiner or the controller who is reading the specification, or any person who is reading the specification, because to understand your invention they have to read the patent specification. So once they read, they have, if they found the advantages, at first they will find the problem solution in the background. Now when you find the advantages, so they can relate out of these invention, what are the advantages they are receiving. Okay, so if we clearly mention that one, it is easily understandable for the examiner or the controller or any other person who will read your patent specification. And lastly, these claims comes into the picture. Okay, so these claims is the main thing, and last actually this abstract. Okay, so in this abstract you can find it should be within 150 words. See, 148 words. Okay, so you have to delete. So there is no way of overcome this one. And there is another thing, these are also some legal requirements. So when you are writing the abstract, there should be an abstract, and obviously there should be a title and the abstract within 150 words, and you have to provide one drawing at the bottom that actually disclose, if you go through that drawing, you will be able to understand the invention as a first step. Okay, so when you see this, there is some drawing in the abstract. You can go through that drawing and you will be able to understand. Okay, so you got a flavor of how this specification looks like, right? Then there is a quiz. So which can be patented and which cannot be patented. So the first one is selfie stick. Can it be a patented subject matter?